morning, and thank you for joining us. Today, we're going to spend some time talking about L-1 visas. These are visas that allow U.S. companies to transfer certain types of employees from companies abroad that have a qualifying relationship with that U.S. employer. So a few things before we get started. One is Scott Legal is a full-service immigration firm. We process many types of visas, including L-1 visas. We will continue our webinar series doing at least 2 webinars a month on different topics. And after this webinar, we'll send you some materials. One is a copy of the PowerPoint that you'll see here today. Another is a comprehensive L-1 visa guide that goes over lots of the L-1 requirements in detail, and also a link to where you can sign up for an additional webinar. So my name is Kelly LeGrand Weiner. I'm a partner at Scott Legal and have significant experience processing L-1 visas over many years. If you have questions through the presentation, please send them in the chat box. We'll leave time for questions at the end of the presentation. And also this webinar is being recorded and will be made available on demand. So let's get started talking a little bit about the L-1 visa requirements. All right, so the L-1 is called an intra-company transferee visa. And so this is meant to allow U.S. employers to transfer certain employees to the United States from foreign companies that they have a relationship with. So for the basic requirements, first you have to show there is a qualifying relationship between the company in the U.S. and the company abroad. This can be a parent, affiliate, branch, or subsidiary relationship. Additionally, both companies have to be actively trading and doing business. So this is defined as the systematic and continuous provision of goods or services. So the L-1 is not appropriate when there's just the mere presence of an agent, without kind of active trading activity. The one exception to this is if the U.S. company has not been, operating yet. You can send an L-1, employee to the United States to open what they call a new office. And when you do that, there are some additional requirements that you need to meet. So on the regular side of the requirements, not new office Ls, which we'll talk about later, the employee that you're sending has to have worked for the company abroad for at least 1 continuous year within the past 3 years. And they have to be working in a managerial, executive, or specialized knowledge position. And we'll talk a little bit more in the presentation about what the definitions of each of those roles are. If you want to get an L-1A visa, then this is a situation where the role in the U.S. is going to be managerial or executive. And for the L-1A, you can generally get this for 3 years initially or 1 year initially for a new office. And then you can keep renewing it, in increments of 2 years up to 7 years. For an L-1B, this is where the person's role in the United States is going to be a specialized knowledge role, though you can renew this for up to 5 years. All right, so if you are doing a new office, so if it's a situation where there's a new company that's been opened in the United States and the company abroad wants to send an employee to, open that up, get operations going, then there are some additional requirements that you would need to meet. So for an L-1A new office, you have to prove that the company has secured sufficient physical premises to house the new office. So, for example, if you're, doing a manufacturing company or something that requires warehousing, or you're, going to have a team of, 10 people that are going to work in an office, you need to be able to explain to the government that you have obtained that sufficient commercial office space to house that operation, whatever it's going to look like. If you're sending somebody over as, an L-1A manager or executive, they must have been an executive or manager for 1 continuous year out of the 3 years preceding the petition. And in the United States, the role they're coming to hold must involve managerial or executive authority over this new operation. You also need to submit proof that the U.S. operation is going to support an executive or managerial role within 1 year of approval by providing additional information to the government about the scope of the office, what its structure will be, what its financial goals are, how much investment has been made into the United States to capitalize the U.S. company and also to pay the salary of the employee who's coming over to start up the business. And then they also want to know about the organizational structure of the foreign company. Um, if somebody's coming over as an L-1B specialized knowledge worker to open a new office, then they need to show proof that the company has secured sufficient physical premises to house the new office and show that the petitioner has the ability to remunerate the employee and to commence doing business in the United States. So they want a little bit more if somebody is coming over as an L-1A manager or executive to open up a new office. All right, so let's look a little bit more closely at what the definitions are of executives or managers. And I think the important thing to remember for an L1 application is that the government is very kind of rigid in how they view what will qualify for, as a manager, executive, or specialized knowledge worker. So whenever you are, thinking about what jobs, what the actual job duties are of the particular person you're sending over, you need to keep these regulatory requirements in mind because the government does have this definition. And if the tasks of the executive or the manager stray too far outside of those, or they feel that, they feel the executive is doing too many hands-on operational tasks, this can be problematic for getting an approval. So you can see here, an executive is someone who directs the management of an organization or a component or function of the organization, establishes goals and policies, exercises wide latitude and discretionary decision making, and receives only general supervision from high-level executives, board of directors. A manager, by contrast, is someone who manages an organization or a department or function of the organization. There's supervises and controls work of others, but it can't be kind of, first line, employees. So if you're kind of a general manager and you are, managing store clerks, that's generally not going to work to prove you're a manager for L1 purposes. You need to show that you are managing other supervisory, professional, or managerial employees. Or if you're making an argument for what's called a function manager, where you manage a function of the company as opposed to, a department with personnel, then you need to show that they really manage that function, that have other people that are doing that operational work. A manager needs to have the authority to hire and fire, to recommend other personnel actions such as promotions, give performance reviews. If they are not directly supervising people, if it's more of an indirect supervision, as a function manager, then they need to show that they are operating at a senior level within the organization. You also need to show, that the manager is able to exercise discretion over day-to-day operations, or if it's a function manager, over the function that they're managing. So it is important kind of when you are assessing whether somebody will qualify as an executive or manager to look at the organizational structure, of the companies. If it's a situation where it's a new office, generally you're going to need a business plan to show the hiring that's going to occur during that first year, and also to make it clear if there are any employees from abroad who are supporting, the executive or manager as they open that new office. Let's look at specialized knowledge. So specialized knowledge under the L-1B visa, this means knowledge possessed by an individual of the petitioning organization's product, service, research, equipment, techniques, management, or other interests, or an advanced level of knowledge or expertise in the organization's processes and procedures. So generally, a key thing for specialized knowledge workers is you need to show that the knowledge they have is not commonly held throughout the industry. So it would not be easy. It's not necessarily the case that the employee applicant needs to have proprietary knowledge of certain products, but if they do have that, certainly it can be helpful. And you do need to be able to demonstrate how, their knowledge is special, is not commonly held throughout the industry, is something where it would be difficult or very time consuming for the company to have that knowledge transferred to another employee. So it's not something you could just learn from a handbook. So it is important with specialized knowledge workers to really make it clear, how, what is their particular knowledge, provide specific examples, maybe provide work product, and really explain, how they have this special knowledge and why it's so much more advanced, than others in the industry. If it's somebody who's really just starting out in their career, maybe doesn't have, decades of experience to explain why they're kind of one of the more advanced people in the industry, but perhaps they've been really crucial in getting the company set up. So maybe they do have really specific knowledge of this particular company's processes and procedures. That can sometimes be, a way to get an L-1B, for an applicant who perhaps, is not as advanced in their career yet, but is extremely knowledgeable and advanced in their knowledge of that particular organization. All right, so what documents need to be submitted for an L1? So one is, you have to submit an application to U.S. Citizenship and Immigration Services. So this is called Form I-129. There's an L supplement that's filed along with this. You also have to submit corporate documents showing that there is a qualifying relationship between the companies. Proof that the companies are doing business. So these are going to be things like tax returns, financial statements, lease agreements, payroll summaries, business plans if it's a new office, proof that the employee has worked for the company abroad for the continuous year in the past 3 years in a managerial, executive, or specialized knowledge role. Pay stubs showing the year of employment, are kind of a good start. But then also to show that the person has been, operating in a role that meets one of the regulatory requirements of executive manager or specialized knowledge worker, you need to include more information, such as detailed job descriptions, organizational charts showing where the person falls in the hierarchy, work product samples that outline how they meet some of these requirements, either work products showing demonstrating their specialized knowledge, or maybe emails showing that they're managing promotions and performance review process if they're a manager. So those things can be very very helpful to help bolster the information that's provided in the petition. And then you also have to provide the same proof that the role in the United States is going to qualify as a managerial, executive, or specialized knowledge role. So if the person, for example, is a VP of accounting, abroad, and they're going to hold the same role in the United States, the information you'll submit will be very similar. It's often the case that the person is perhaps coming to a new role, maybe they're being promoted. So in that case, you need to prove how each separate role meets one of these regulatory requirements of executive manager or specialized knowledge worker. You also need to show within that, if the person is coming to the US to hold a different role than they held abroad, you need to emphasize how they have the skill set and experience to hold that new role. So you want to, for example, if it's a promotion based on their experience that they gained at the company abroad, you want to kind of emphasize that in the resume and in the job experience letters, so it's clear why they're being sent over to do this particular job. All right, so let's talk a little bit about requests for evidence. So requests for evidence, when you submit an application, to the government, sometimes they will come back and ask for more documentation to prove that, the case meets all of the requirements. And unfortunately, the L1 category, at times has been abused, by some very large companies. And as a result of this, there's lots of requests for evidence that are issued for L petitions. You can see, the statistics show that, over 50% of L petitions, receive requests for evidence. So you can see that the government does interpret the regulations and the requirements kind of very strictly, even though they may seem straightforward. Ultimately they do hold companies and petitioners to very rigid standard in meeting all these requirements. In particular, what is, they're very strict about who gets to be qualified as a manager, executive, or specialized knowledge worker. That's a very common, question in the request for evidence is, prove that this person is a manager, prove that this person is an executive. So things that can be helpful in responding to these types of requests are, one, detailed support letters. So the more specific you can be, the more examples that you can give, that not only kind of reflect the regulations, but show how the person's job, so for example, email is showing someone doing a performance review, or engaging in a kind of a promotion process, or hiring or firing. Those can be really important for proving someone is a manager. Providing documents showing that the people being managed are professionals. So if you can provide resumes or bachelor's degrees, or hire of people being managed, that can be very helpful as well. They also want to see objective evidence to support statements in the letters and the charts. So things like work product with kind of explanatory, cover letters explaining here's a handbook that was drafted, and here's why it demonstrates, X, Y, Z. If somebody's coming in as an executive and they've written, and established kind of the policies for the organization, you could provide the policy handbook showing that they're the person that has the authority, to create and implement this policy. So these are all important things to include to supplement any statements you're making in support letters that you provide in the L1 application. All right, let's talk a little bit about timing and dependence. So the way that the L-1 process works is that the L petition itself first has to be approved by U.S. Citizenship and Immigration Services. So this is, mailed within the United States to USCIS. Normal processing times are several months. You can also pay an additional the fee just raised to $2,805 for premium processing to get an answer within 15 business days. So these changes are happening. The fee increase has already happened, and then the 15 business days as opposed to 15 calendar days will be starting after April 1st. So, within that time frame, you can get an approval, a denial, or a request for evidence, or more unlikely, but sometimes you'll get something called a notice of intent to deny. So that's exactly what it sounds like. It means they plan to deny the petition. They give you kind of 30 days to submit a response explaining why the petition should not be denied. So it's definitely worse to receive a notice of intent to deny than to receive a request for evidence. It's much more common to receive a request for evidence. But if you do get a notice of intent to deny, those can potentially be overcome based on the reasons for receiving it. But it is a more difficult standard to meet because in that circumstance, the government has already said, they don't feel that the petition, is approvable. So assuming the petition is approved, after it is approved by USCIS, if the employee is outside the United States, they'll schedule an appointment at a U.S. consulate to get their L-1 visa stamp. Or if they're a Canadian, they can go to the border. And if it's an initial L, they can process their L1 right at the border. Or if it's a renewal, they can take their approval to the border and get, the L1 written into their passport to travel. If the person is already in the US in a valid status that allows them to change status, they can change to L1. Or if they're here on the L1, they can extend their L1 from within the United States and then just go get an updated visa stamp if needed, at a later time, whenever it works for them. Spouses and unmarried children under 21 can accompany the employee. They'll receive L2 dependent visas, and this does permit the spouse to work anywhere just on the basis of being a spouse. So as long as the I-94 says L2S for L2 spouse, that I-94 can serve as work authorization. And then the children are permitted to attend school, but they are not permitted to work while they're on L2 status. So a very common question is, does an L1 lead to a green card? And I think there is a perception that if you're on an L1, eventually the transition to the green card is, almost inevitable. And this isn't the case. I think that if you do come on an L1, there often are paths to green cards available to you, assuming that the company you're with wants to continue, to assist in the immigration process. But there's nothing automatic about it. It's something that has to be applied for based on certain, qualifications. So one very common option is the L1A to EB1C, multinational manager or executive green card. So this is a green card, for managers or executives. The requirements really do mimic the L1A, but they do put a heightened standard on it. So for example, if, and you do have to have been a manager or executive abroad. So if you were a specialized knowledge worker abroad, and then you came to the United States and became a manager, that's not going to work for the EB1C because you need to show that you held an executive or managerial position abroad and that you also are holding an executive or managerial position in the United States. So it is something where even if, let's say you've been here for, 6 years, they may ask for, additional proof over and above what was previously submitted for the L1 about your job abroad. Sometimes even if it's several years ago, they'll ask, what did the organizational structure look like at that time? Provide us with work product, provide us with evidence. So, they do apply this heightened standard. And so it is something to be aware of, that even if you've been approved on the L1A, it doesn't necessarily mean that USCIS will defer to that finding that you were a manager or executive abroad on the L1A. They, for the EB1C, they may still ask for more documentation about that. So you should be prepared to provide that, if needed. The benefit of the EB1C is that you can, one is the EB1 category. So as an immigrant visa category for green card availability, it's usually is current for most, most people. There are some backlogs for kind of, nationals of India or nationals born in India or people born in China. But more than the other categories, it generally has not as extensive wait times. And then additionally, you don't have to engage in the labor certification process where you test the US labor market to see if there's any willing, qualified, and available workers for the job. You can skip that entirely and just file the I-140 petition with this proof of the qualifying relationship, that the companies are doing business, and then proof that you held an executive or managerial job abroad and that you will hold one or have been holding one in the United States, and that the company can pay this wage. For L-1B, specialized knowledge workers, a green card may be available for them as well, but not under the EB-1C. They would need to go through, something called the PERM process. So this is where the government will test the U.S. labor market to see if there's any willing, qualified, and available U.S. workers. It requires the company to kind of get a prevailing wage, indicating what they'll pay, go through the recruitment process, file the labor certification. So all of that together, given the Department of Labor's long processing times, that can be a process of a couple years just in itself, even before you get to the I-140 and the green card part of the application. So if you're on an L-1B, you only have 5 years, until you need to leave the US or find another status. So it can be better to, talk, if you are interested in a green card in the L-1B, it's sometimes better to talk to your employer about it up front when you first arrive in the United States to see if you can get that process started more quickly, because it will take some additional time. And, with the EB-1C, there's an ability to pay an additional fee and get, an answer within, 45 days. There's not an ability to do that, with the L-1B, with the PERM. The PERM process generally can't really be expedited in that way. Once you get the PERM approved and you get to the I-140 stage, then the I-140 you could pay for premium processing. But it's the actual PERM part of the process is pretty much, you're subject to the Department of Labor's processing times. You're not going to be able to expedite pieces of that. So you do need to plan, for those additional few years. There may also be other options for an L-1B applicant, who's pursuing a green card, depending on, their background, what they're doing in the United States. For example, if they have, a master's or exceptional ability in their field and they're working on, an endeavor that has substantial merit and national importance, perhaps they could, try to go through the EB-2 national interest waiver process. But that really depends on, the applicant having a very impressive background as well as the specifics of what they're working on. So I'd say it's a less common process for L-1B than the PERM process, but certainly worth exploring, all the options. All right, so we've reached the end of the presentation. I see we have one question. Someone's asked, I'm under L-1B. I registered in the H-1B lottery. In case I win, can I wait to file my H-1B? So if you do win the lottery, then you are required to file within the 90-day filing window, between, April 1st and June 30th generally. So it does have to be filed within that window. If you then get the approval, but you don't want to change status to H-1B, you can get the approval and go, through consular processing and go at a later time to get the H-1B abroad. But you do have to, if you want to proceed with the H-1B, you do have to file it within the filing window after being selected. All right. So it looks like we don't have any more questions. So thank you so much to everyone for your participation. And let's see, how long the petitioner company should be operational in the US for filing for an L-1B. So it is possible to do a new office L-1B. That's where the company has not been operating for, a year yet, but the person's being sent over to open a new office. But in that case, there'd be the additional requirements that we discussed, as well as, the person will only get the visa for 1 year. And then the hiring would need to be quite aggressive during that year, I think, to get an extension on the L-1B. All right. Thank you very much to everyone and have a wonderful day.